You're here today without a lawyer. You want a lawyer to help you?
Yes,
Oh,
sir.
you got the application completed. Look at that. Perfect. All right, looks like you qualify. I'll appoint the public defender to represent you.
Thank you, Judge. Cynthia Presume in 25 CF 1513 will be entering a not guilty to all counts, waive formal reading, and request this be kept on the pretrial docket, Judge.
When's it set, Madam Clerk?
November 10th at 9 o'clock.
Do you want to leave it then, or you want to move it up?
Can we move it up, Your Honor?
Yep. You want to move it up to September the 8th?
September the 8th. Yes, Judge.
All right, so move it up September 8th.
Here's your next court date. But call today, make an appointment, and we can discuss this by phone about even waiving your appearance for next. Okay? So call, make an appointment, and you're free to go.
Thank you.
You're welcome. Thank you. Thank you, Judge. And we are recalling Mr. Juan Perez Rodriguez from this morning, 25 CF 1281, 25 CT 1281.
Your information has been filed, or the...
Yes.
All right. You confirm, Madam Clerk? Uh, 25 CT 1281.
Not saying that's not filed, just something not been processed yet.
I have a copy on my computer of the one that was filed. If I,
The court find the plea to be freely and voluntarily entered into, and will accept the plea on the terms and conditions freely announced.
Thank you, Judge.
thank you, Judge.
Please enter. All done.
Ya entramos en declaración, ya su caso está terminado.
Correct?
Correct.
All right, thank you.
Your Honor, if I can call Mr. Donnell McLean, case number 25 CF 1497.
Good afternoon.
Your Honor, we'll acknowledge receipt of the information, enter a plea of not guilty, and ask to leave this set for the November 10th court date.
All right. So ordered.
Thank you, Your Honor.
Thank you. Good day.
God bless you.
If I may call a couple in the courtroom, Judge. Ms. Cynthia Slay. This is 23 CF 2462. Yep, thank you. Yes, Your Honor. We acknowledge receipt of the information. We will be entering a no contest plea to the charges. This is going to be an adjudication of guilt, 24 months Department of Corrections, credit for time served. State and defense stipulate that the 24 months of the sentence has been served already. She had a Walton County case, and I did provide it on the plea form, 6623 Charlie Foxtrot 658. So ultimately a credit time served offer, 615 in court costs, 150 defense costs, and there's a prisoner transport to the Okaloosa County Sheriff's Office in the amount of $253.60. All counts to run concurrent. If I may approach with a signed plea form and score sheet.
Granted.
That's the state's agreement.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You can put your hand down. You heard what Mr. Couch said on your behalf,
Yes, yes,
and you signed the written plea form.
yes, sir.
This is a bit unusual of a plea because you're pleading no contest to the charges, which says that you believe the state can prove your guilt and you're not going to contest that. And you're waiving your right to a trial by jury.
Yes, sir.
You're pleading to a Department of Corrections sentence, but the state and the defense are agreeing that you already have all the time that you have. So essentially, this is a credit for time served sentence. You understand? Okay.
Thank you.
Now, Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, how much time do you think you need to get these fees and costs paid?
Probably about a year.
Okay.
Mhm.
All right, very good. Thank you very much.
Okay, thank you.
Step over this way, please.
Fingerprints. Excellent. Judge, if I next call Mr. Timothy Schlegel in two cases, the 24 CF 759, 24 CF 1109, Your Honor.
All right, go ahead, sir.
Judge, receiving the information, we're going to enter not guilty on all counts and waive formal reading. Request to be kept on the pretrial docket.
And that's set for when, Madam Clerk?
September 8th.
All right. Stay in touch with your lawyer and see you on September 8th.
All right, thanks, sir.
Thank you now, good day.
November 8th, next court date. Make that phone call, make that appointment. Judge, that's all I had present in the courtroom.
All right. Mr. Cochran?
I have no one else present in the courtroom at this time, Your Honor. I do have one, I'm asking to waive his appearance, Mr. Anthony Lucy. We had him in court, I believe it was last week, on the bond issue. I believe we addressed this, I'm not sure if we did, but I would like to waive his appearance, enter a plea of not guilty.
Objection to the waiver?
No objection, Your Honor.
Set for when, Madam Clerk?
September 10th?
It's set for September 10th.
Thank you,
I'm
Your
sorry,
Honor.
November 10th.
I'm sorry, 11/10.
Thank you, Your Honor.
All right.
Judge, I do have one more in the courtroom if I may call.
All right, go ahead.
Miss Lindsay Rosen, who's present and approaching, 25 CF 1456.
All right.
Good afternoon. Judge, we'll be enter not guilty, waive formal reading, and request to be kept on the pretrial docket.
All right. And it's set for when?
November 10th.
Leave it there.
Yes, Judge.
All right. Stay in touch with your lawyer, be back in court then, okay?
Thank you, sir.
All right, good day.
Actually, Judge, the out of custody, I apologize, the 9/8 docket?
November. Or-
Oh, I'm so sorry. You're right. I apologize, Madam Clerk. Long day.
Yes, indeed. And it's not
Call,
all.
schedule appointment to come see me, but that's our next court date. All right? Yes, ma'am. And that's all I had present in the courtroom.
All right. All right.
Good afternoon, Your Honor. Mr. Teddy Lanu, Your Honor, we're enter a plea of not guilty. I'm sorry. We're gonna. One moment, Your Honor.
Say again?
If we may readdress him in a moment, there might be a plea.
Okay. So let's hold Mr. Lanu, okay? Who's this?
This is William McPhee. One second.
Say again?
William McPhee, Your Honor. If I may have one moment, Your Honor.
Yes, sir.
to get everything signed. Your Honor, at this time, in exchange for a plea of no contest, the state has agreed for count 1, a withhold of adjudication, 2 years probation, substance abuse eval and treatment, 48 hours community service, cost of prosecution and cost of defense. As to count 2, it'll be a withhold, 2 years, the same conditions, 2 years probation with the same conditions. Count 3, also a withhold of adjudication with the 2 years probation and same conditions. As to count 4, it'll be a withhold of adjudication and credit time served. If I may approach, I have the signed plea agreement and the score sheet.
Probation has a question. Are those community service hours concurrent or consecutive? Like, is there any 48?
Concurrent.
Concurrent, just when.
All right, raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
And you can put your hand down. You heard what Mr. Cochran said. You signed the written plea form.
Yes, sir.
How old are you?
33.
How far did you go in school?
1 year of college.
Be able to read and understand the plea form.
Yes, sir.
Did you do that before you signed it?
Yes.
And it's what Mr. Cochran announced, what you read the plea form.
Yes, sir.
Do you understand that you're pleading no contest to the announced charges,
Yes.
waiving your right to a trial by jury?
Yes.
Adjudication will be withheld. You're going to be on 2 years of probation with the announced conditions, including this community service. And Madam Clerk, proper fines, fees, and costs.
$6.15.
And plus $150 cost of state-provided legal assistance. Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how he's represented you?
Yes.
Court will find the plea to be freely and voluntarily entered into and accept the plea with the withhold.
Thank you, sir.
Thank you, Your Honor. Thank you, Your Honor.
All right, and you're not represented by an attorney at this time, Mr. Muncy, is that right?
Byron Cottons could be my attorney, Judge.
Have you hired him?
Yes, Judge.
Does he know to be here today?
I called him and he thought that today was going to be where I just plead not guilty and that he usually sends a letter.
Okay, the court will enter a not guilty plea. When's it set for pretrial, Madam Clerk?
November 10th.
Okay, it'll remain on the docket for 11/10. Let Mr. Cotton know, and if he needs to advance it on the docket, we'll let him do so, okay?
Yes, Judge. May I explain the protective order that's been issued against me?
I'm sorry?
There's a protective order that was issued against me, which is, I believe, the reason why my bond was set so high. At least it was referenced in the...
Well, I really am not comfortable. You've told me Mr. Cotton's representing you. I'm not comfortable proceeding forward, and we're here only today for the arraignment. And therefore, if there was going to be a bond issue, the state would need to be notified and be made aware of that. Does that make sense?
Yes.
So that, address that with Mr. Cotton, and if he wants to set a bond motion, then he can do that at any time. I put them on as soon as I possibly can.
Thank you.
Okay? All right, thank you now.
And do you want this for November 12th for inmate?
Yeah, November 12th, I apologize. All right, Mr. Cochran?
No, sorry.
I believe this belonged last time.
Yeah.
Yes, sir.
Your Honor, at this time, we'll acknowledge receipt of the information, enter a plea of not guilty. We ask to leave this set for the November 10 court date.
All right, so ordered. November 12th.
Yeah, I remember that. That's not good to see. Your Honor, we're here on Mr. William Moore, 25 CF 1519. Your Honor, we acknowledge receipt of the information, enter a plea of not guilty, and ask to leave this set for the November 10th, 2025.
So ordered. Actually, 12th for him, right?
Right. The 12th for the inmate,
Yes.
yes.
It's Mr. Eddie Register in 25 CF 1444, Judge.
All right.
They filed formal charges. We're going to acknowledge receipt, enter a not guilty, waive formal reading, and request this be kept on that pretrial docket.
All right. 11/12.
Next court date. This is Mr. Rivera Soto in case number 25 CF 1400, Judge.
All right, go ahead.
Judge, received formal charges where we enter in a not guilty, waive formal reading, request this be kept on the pretrial docket.
So ordered.
And I believe that is the 9, 10, no,
11, 12?
11, 12. Thank you, Madam Clerk. Thank you.
And Your Honor, that concludes my business, if I could be excused.
Thank you, ma'am. Good day.
Thank you, Judge.
This is Mr. Rubink in case number 25 CF 1515, Judge. Judge, receiving the information, will enter a not guilty, waive formal reading, request to be kept on the pretrial docket.
11/12, Madam Clerk. All right.
That's our name. Thank you.
Isn't he one of yours, though?
Judge, he has Miss Dudley in a separate case. As of right now, in this case number 25 CF 754, I show him as unrepresented.
All right. So, Mr. Rudolph, do you wish to be represented by an attorney in this case? Is Miss Dudley going to pick you up in this case?
I would like one more continuance, and then after that, if I don't resolve the issue with my lawyer, then as far as retaining her on this case, then I'll take public counsel.
Okay, so you're still trying to negotiate for her to cover you on this case?
Yes, sir.
All right, stating the objection, and we're talking a 2-week continuance, right?
Correct. I don't have an objection.
When's our next plea day? What habits are there? Our next arraignment date?
September 11th.
All right, so you'd be 9/11.
All right.
All right, thank you now.
Your Honor, that's all I had before the court, if I may be excused.
Well, I see Russell Allen Snell III on my list.
That is, he's represented by Ms. Jaquette, and not guilty plea has been filed.
Okay, so sorry to impugn you. That was a written plea not guilty?
Yes, Your Honor.
All right, and I see then also Nicholas Raybon.
Judge, the state intends to file a no cross in that case.
And not guilty plea has also been filed.
By
Ms. Jaquette.
Ms. Jaquette. Okay. All right. And did we take care of Rangel Morales? Savannah Ray Rangel Morales?
I want to say that's going to be,
I got this. We played out all her cases on 8/14, Judge.
The court date was canceled, so that makes sense.
Yep.
8/14.
We played out everything, yep.
Okay. It's still on my docket. Okay. All right. And Fernando Delano Payne.
He was present, Ms. Jaquette, she filed a waiver, and I verified that online.
That's correct. Not guilty plea filed by Ms. Jaquette.
All right. Okay, thank you.
Thank you, Judge.
All right, looking for Willie Lee.
I know that, so when we pulled our docket, it had not populated on for quite some time. I don't know if he was able to actually get a notice of appearance for this court date.
Yeah, I don't see such.
I mean, would you recommend we put him on the 9/8 or, did I say, yeah, 9/8 or?
Would be 9/11, just continue the arraignment
Okay.
for 9/11.
If I may have one moment, sorry.
Say again,
If I could have one moment, I'm sorry.
you're representing Willie Lee?
Oh, no, Your Honor.
Okay.
There's also another one, I think, that was not in custody that we were, and maybe I missed this, Fernando Payne. Did I miss that one?
We just talked about Fernando Payne. I think he's got Ms. Jaquette now, and she filed a written plea not guilty.
Sorry, Your Honor.
That's okay. Elijah Medina.
That one, Your Honor, I believe was transferred down to misdemeanor. That's what I have on my docket. I had to go through a lot of hoops to get that transferred down, but I believe it should have been e-filed and transferred to misdemeanors, Your Honor.
Madam Clerk?
I'm not showing that yet, but I do show that a not guilty plea was filed.
All right.
That was done at 8.
We let Mr. Koch go before we talked about Dylan Riggins. No, it's okay.
I believe he handled it this morning.
Did we handle Dylan Riggins this morning, Madam Clerk?
Yes, Your Honor.
Okay. Why was he on both dockets?
VOP only in place.
Okay, so on Jacob Real, looks like Miss, who's that?
That's not how that works.
Oh, sure.
Yeah, that's not how it works. So he can make choices.
Orlando attorney?
That's not what he has to get up today.
Okay, so on Jacob Real, Christina Vasquez filed a written plea of not guilty, and so the case is now set for the pretrial on 11/10. I wonder, it's just slow populating, is that what the problem is?
I guess. So the only ones I have are Fabian McMurray and Albert Taylor, so one Mr. Cochran, no attorney.
Albert Taylor is in the process of being transferred to division.
Devon Spell. So you're transferring Taylor where?
Taylor to Division 1. In the Spell case, probably, Ms. Merrifield probably filed a written plea on that.
That's correct.
Is this what you show, Madam Clerk?
Yes, Your Honor.
Okay.
For Albert Taylor, we'll do a control date for plea day of September 11th.
Right, just for status only. That way we'll be sure it's actually done, okay? Does that cover them all?
That covers them all.
All right.
It's McMurray, Mr. Cochran.
I'm sorry?
Kavion McMurray,
Yes.
that's the last one that we have.
We have that and Mr. Lanu.
Okay.
Mr. McMurray is going to enter a plea. I'm sorry? Yeah.
Like I said, we can't enter the case for today. We have to go next Wednesday or on Wednesday. They're gonna take you and we'll ask you if you wanna do it, and then we'll tell you it. All right, that's the process. Okay.
Your Honor, at this time, Mr. Lanu We're going to acknowledge receipt of the information. We're going to enter a plea of not guilty. Leave it set right now for the November 10th or November 12th court date, with the understanding that this may fall off the docket as going into drug court.
Okay. All right, very good.
Thank you.
See you then, and if it comes up, then we'll take care of it.
So it's like I said before, it's a withhold, so you're not a felon, 2 years probation, 48 hours community service. This is what we talked about at the jail. Yes, sir. Okay. Did you get a chance to read over this?
Not yet, did he just get it?
Okay.
Your Honor, while he reads this, may I address the 230 case?
Yes, sir.
Sorry
Mr.
about
That's all right. Ryan Curtis Black, 2024 CF 2873.
Can we approach?
Yes.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at
Your Honor, today Mr. Kayvon McMurray is going to enter a plea in case number 25 CF 1449. My client is going to enter a plea of no contest. In exchange for that plea, Your Honor, the state has agreed to a withhold of adjudication, 2 years of probation, with 48 hours of community service.
And forfeit all firearms.
And forfeit all firearms. If I may approach, I have the signed plea agreement and score sheet.
All right, and so as you know, on these forfeit all firearms, the court has experienced this in the past. Does the defendant claim that anyone else may have an ownership interest in the firearm?
No, Your Honor.
You're not saying anyone else owns that firearm?
Okay. All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard what Mr. Cochran said, and you signed the written plea form?
Yes, sir.
All right, how old are you?
You said how old am I?
Yeah.
21.
And how much school do you have?
I was locked up. I was in juvenile, so I don't know, like maybe 10th grade.
Okay. You able to read and understand the plea
Yes,
form?
sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read, what Mr. Cochran just said?
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to the charge?
Yes, sir.
And that says to me you believe the state can prove your guilt and you're not going to contest it.
Yes, sir.
Do you understand by making this plea you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
And in this case, Adjudication will be withheld. You're going to be on 2 years of probation with the 48 hours community service and other standard conditions of probation. You'll forfeit the ownership of the firearm, and you'll have the standard fees and costs, which are, Madam Clerk?
$515.
And $150 cost state-provided legal assistance. Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea with a withhold.
Thank you. I believe that concludes my docket, Your Honor.
Was that all of them, Madam Clerk?
Yes, Your Honor.
Okay, good.
I believe that is all for me as well, Your Honor, not be excused.
Yes, sir.
Sheena Russell in the document?
Sheena Russell, yes, it does. 22 CF 1743.
I've got 3 witnesses I anticipate, and I'm going to, if I can, call them in so they can come in here.
Yes, sir.
Judge, I anticipate 3 witnesses. I don't know where we're at. We're waiting for Mr. Flowers, client. We're ready.
We're ready to proceed, Your Honor.
This is Sheena Russell. It's case number 22 CF 1743 on Gillespie for the state. Judge, she entered a plea back a few months ago to a single count of elder exploitation. That was back in May of 2022, or May 22nd, 2025. There was a PSI that was awarded. I've received a copy. I don't know if the court's reviewed it.
I have.
I believe.
Judge Mike Flowers and Tim Shaw for Ms. Russell. We've received a copy of the precinct's investigation and have reviewed it as well, and we're ready to proceed as well, Your Honor.
Are any
material-
corrections to the PSI, any changes?
Yeah, my apologies for interrupting. No material changes or corrections from our perspective, Your Honor.
And none noted from state. I do have a couple witnesses to sort of expound upon some things and a couple other details for the offense. But other than that, I did not note any errors.
Mm-hmm.
So without further ado, I guess, again, she had pled there is a cap of 7.5 years as set for the incarcerated period. I was been in the restitution that was stipulated to. I will for the court and defense, I spoke with them. There was a reduction in that. We noted something, and I provided those documents, that there was a $8,203.61 that will be subtracted from that restitution amount. I've talked with them about that. We can get the order done for sentencing. Other than that, she did provide $100,000 in restitution immediately as part of the plea as it's stipulated. What I'd like to do is call, I guess, the first witness and kind of discuss some of this.
All right, so is the amount on the plea agreement before or after the $100,000?
Sorry?
Is the amount on the plea agreement before or after the $100,000?
That was before, so the total amount, for their benefit on this, should be $707,333.21, and that's with that reduction, total amount.
Okay.
Yeah, that's what we believe to be accurate, Your Honor.
All right. You got that number, Madam Clerk?
707,000. Can you repeat it, please?
Would you repeat the total?
Well, let me double check. $707,333.21 is the total restitution that's owed. The total owed to the amount that's reduced here is total amount owed to Rita Shuck has been reduced to $365,984.57.
And that was the only reduction of that amount, because the plea agreement then listed other restitution paid.
That's correct. There's other financial institutions as well that are broken down.
But those numbers remain the same?
Those numbers remain the same.
Okay.
The amount that's changed is the ones I've detailed.
Okay. All right, very good. Thank you.
If we can call Mr. Jerry Pack.
Good afternoon, sir. If you'd raise your right hand and be sworn by the clerk. Madam Clerk.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please be seated. Direct your voice to the microphone you see in front of you. It's important that we're able to hear and understand you. And also, there's a court reporter in the back of the courthouse taking this all down, so it's important that they're able to make a good record.
Okay.
If any of the lawyers object, please stop speaking until you receive an instruction on how to proceed. Is that okay?
Okay.
You may inquire, Mr. Gillespie.
Would you please state your name for the record? Spell it.
Jerry Peck.
And your last name is P-E-C-K?
P-E-C-K, Peck.
Okay. And you know Miss Rita Shuck, the victim in this case?
Yes.
How do you know her?
She is my sister.
Okay. And where do you live currently?
I live in near the Kansas City area, Missouri.
Okay. And Miss Rita Shuck, where did she live back in 2019 to 2022?
She lived in Destin, Florida.
Okay. You as the brother, you're aware of the issues involved in this case, the offense and the elder exploitation?
Yes.
Okay. Miss Rita Shuck now, currently, where is she?
She's in a assisted care in St. Joseph, Missouri.
Okay. And she has cognitive issues or dementia?
She has the beginnings of dementia that keeps gradually getting worse.
Okay. And so you're speaking on behalf of her and the family?
Yes.
Did you prepare a statement today that you wanted to let the judge know?
I have a prepared statement, yes.
Would you like to share that with the judge
Okay.
now?
What I have here is kind of a little background of the way it went, and I'll try to shorten it so it's not too long.
Take all the time you feel is necessary to explain why what's important to you.
Okay. My sister named Rita, and she was married to a
military guy that was in the Air Force. They got married in 41, and he retired in 1966. They bought property in Destin at that time. They both came from farm families, and they were thrifty and knew how to save. During their military service, they moved every couple of years from time to time, and they would buy a home, fix it up, make it better, reinvest that money when they moved again, buying a little bit better home and fixing it up, and continued that. That's how they built a, not a fortune, but they built a savings. In December of 1999, they set up a trust with the Northwest Missouri State University, and they created a scholarship fund there in their name that could be used later on, because all that money in the trust would be going back to the college. Rita and Warren used to go to the Olive Garden here in Destin, and that's where they met the defendant 10 to 15 years ago, as far as I know. It could have been a little bit longer or more. Rita's husband passed in 2015, and she at that time asked me to be a power of attorney on the trust, which I did. And the trust, she said, it's pretty well all taken care of, because it's just stock purchases that they made. The stock dividends went back into the stock, and they bought more stock later on, and that's the way it grew. Anyway, the defendant was a waitress, like I said, Olive Garden. They met and started befriending my sister, doing errands and driving her to appointments in the bank, etc., and gained her trust. And she even got a medical power of attorney in April of 2020. In September 2020, the defendant took my sister to the our Fort Walton Beach Medical Center at the doctor's request, and she delivered her there. She left her phone number as a contact if it was necessary, and drove away, is all I can say. The hospital did need some information, and they never could contact the defendant. And they sent my sister then to the Destin rehab area, medical unit, and my sister talked her way out of it about 4 or 5 days later. In June of 21, I got a call from the neighbors here, her neighbors here in Destin. It says that she was feeling ill and that I should come and see if she didn't need more attention. I caught a flight out of Kansas City the next day, and when I seen her, she was very sick and laying in the bed and couldn't hardly move. And I called the ambulance, and they took her to the Ascension Sacred Heart Hospital, where she was diagnosed with cystis, and was there for a month of treatment and rehab. While she was here, coming back every now and then trying to straighten the place up and take care of it, I found some paperwork that showed some withdrawals on the USAA May 2020 statement, and it didn't look right, so I called USAA, and found out there was 4 deductions made, and that was for about over $180,000 during the month of April, May. And then the stock transferred to Charles Schwab, and I thought, well, maybe if it happened here, maybe Charles Schwab had some problems. Checked with Charles Schwab and found out that she had made 16 withdrawals there and withdrew over $400,000. I didn't know about any of this stuff because I found out later that the defendant had gotten into the account, set up an online account, a paperless account, and so there was no more paperwork going to the house that my sister received after that point. Anyway, this makes a long story. It kind of covers the points here, and I just want to have the defendant to receive the maximum amount of time by law, and probation to pay for a full restitution. She befriended my sister, gained her trust, and then stole from her. And I think that should be the reason for my referral here. So with that, I'm done.
Let me ask you just a follow-up on that. There's a request for restitution, obviously. In your opinion, does that outweigh a need for a prison sentence in this case?
No.
Okay. Ms. Rita, she's been basically recouped some of this money already to a degree, and she's doing financially okay?
She's in good shape.
Okay. And there's no worry about her becoming destitute, essentially?
No.
Okay. Is there anything else that you want to let the judge know?
No, I think that's enough.
Okay. I don't have any other questions at this time.
Mr. Flowers, Mr. Shaw, you wish to inquire?
I have no questions, Your Honor. Thank you, sir.
Okay. Thank you very much, sir. Your next witness, Mr. Gillespie.
Call Investigator Kruger.
Investigator Kruger, please. Good afternoon. If you raise your right hand, be sworn by the clerk.
Do you swear to affirm the testimony about this will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Please be seated and direct your voice to the microphone. Speak clearly and distinctly so we can hear and understand you. And if there are any objections, stop speaking until you receive an instruction, okay?
Yes, Your Honor.
Mr. Gillespie, you may inquire.
Would you please state your name for the court?
Michael Kruger.
And where do you work?
Okaloosa County Sheriff's Office.
How long have you been with that office?
Over 10 years.
And what are your duties currently with the office?
I'm a senior investigator for financial and economic crime.
And how long have you been doing that?
I've been doing that for 8 years.
Do you have any specialized training in that field?
Yes, I have a master's degree in criminal justice, and I have a CFE, Certified Fraud Examiner.
Okay. Are you familiar with this case involving Sheena Russell?
Yes, sir.
And you were the primary investigator in this?
Yes, sir.
Okay. You received essentially contact from them that there were some unusual transfers to accounts from theirs. Is that right?
Yes.
Okay. And did that lead to the defendant's account with Darden USF?
Yes, that was what we subpoenaed, Darden.
And you were able then to identify that that money was flowing from Sheena Russell's account, or I'm sorry, from Rita Shuck's account into Sheena Russell's account with Darden?
Yes, starting with USAA and then Schwab.
And that was a large amount of transfers?
Yes, sir.
Okay. Can you kind of detail some of those?
Yes. From March until May was USAA. There was 4 of them. It was close, above 160,000. And then after that, from Schwab, it just escalated 400 and something thousand. And the items that were being purchased were trips to Disney. They went to Utah, Colorado, ski trips, Washington, D.C., the Atlantis resort in the Bahamas. So
You did some review of that, and it appeared to not be for the benefit of the victim.
Yes, definitely not for the benefit of the victim.
And you obtained some certified business records from USF, is that right?
Yes, sir.
Those were basically the recordings and then these, or the bank records, but also some recordings, is that?
Yes, customer service recordings.
Okay. And you reviewed those customer service recordings?
Yes, sir.
And what is Ms. Sheena Russell on those recordings?
Yes.
What does she detail on that?
I guess she receives a call from customer service talking to her about a transfer from Charles Schwab to explain to her that her account has been frozen because they believe there's some fraudulent activity in that recording. She's talking to Sheena about it, and she asks what's the nature of these transfers, and she said, well, we're in business together, and that this money is coming to her. It's not free money. This is, she's got to pay it back.
And she had said that was and this is, I guess, a timeline of this. This is after Ms. Russell's already moved to Missouri, is that right?
Yes, sir.
Okay. And these transactions were occurring post that move?
Yes, sir.
Okay. And she had said that she was in business. What kind of business did she detail?
Property management.
Okay. Did you look into that?
Yes.
Did you see anything in her business or her bank records that seemed to indicate a business?
Nothing overtly showing that.
And then we provided documents the state attorney has required and you've reviewed. Is there any business entity under Sheena Russell or Rita Shucka's name in this area?
No, sir.
Okay. You also obtained some records from Charles Schwab and USAA?
Yes, sir.
Okay. And that included some bank records and other records, including recordings?
Yes, sir.
And we additionally acquired some of those recordings that you've reviewed, is that right?
Yes, sir.
Okay. In those recordings, does Rita and Sheena Russell appear together?
Yes, at the very beginning, it's Sheena's on the recordings. It explained to them that she's assisting Rita to try to figure out, I think it was, the first one was how to cancel a auto insurance payment because her auto insurance had been dropped. And then following that, it was, how do we get access to the account for her because they needed to get money for her assisted living. During that time, she's on the phone with Rita, and Rita says, yes, you can talk in front of her. And when they're verifying Rita, though, Rita is actually giving her passcode to get into the account and other personal information in order to access the accounts.
If I can approach with states 1, 2, and 3.
Granted.
You recognize these? I'm going to show you states 1. Which is USF. You recognize that?
I do.
Those are those recordings of 2?
Yes.
And then I have Exhibit 2, which is USAA Federal Savings Bank 4 recorded phone calls.
Okay.
You recognize that too, as those recorded phone calls?
Yes.
And then I have a USAA Investment Services 6 recorded calls, Exhibit 3.
Yes. Yes.
They like to admit these into evidence?
There's no objection, Your Honor. We've seen her and are familiar with those items.
And
They're
we've kind
admitted.
in detailing that, there's, again, those recordings, you'd mentioned that at the beginning of one, she's on the phone and listening in and helping her, essentially. Is there another recording that caught your interest in this?
Yes, the third recording. There's a voice that comes on that says that she's Rita, but it's definitely not Rita. It appears to be a younger person due to the cadence of their voice, the types of language they're using, and the knowledge. And also, previous recordings that Rita, anytime they asked her name, she would spell out her name, R-I-T-A, and then Shuck. She would spell that out right afterwards. So this wasn't the same.
And that was the March 23rd recording?
Yes, sir.
Okay. Judge, if I can publish to you, I have the recordings.
Yes, sir, just a second. Go ahead, sir.
And what I'm going to do, I'm going to publish, there's a recording where she spells out her name. Those are in the USAA 4 recorded phone calls. I'm not sure if you can hear this or not.
Thank you for calling USAA. This is Jeremiah, your banking specialist. How may I assist you?
Yes, this is Rita, R-I-T-H, S-H-U-C-K, and I need some information. They need my,
So I'm just going to play these one by one, sort of showing that how she operates or how she answers the phone there.
Thank you for calling USAA. This is Jackie at Baby Deposits. How may I help you? Yes, Jackie, this is Rita, R-I-T-H, S-H-U-C-K. I have been talking to her very, very old.
I'm going to play another one.
Good morning. Thank you for calling. Thank you for calling USAA. My name is Paul, I'm a specialist today. Who do I have the pleasure of speaking with?
Rita, R-I-T-H, Chef, S-H-U-C-K.
Okay, thank you.
So now I'm going to play the ones where she appears to be with Sheena Russell. I'm going to play the one that's marked March 10th. And I may skip around here a little bit to, if they're longer calls, about 20 minutes.
USAA. My name is Jonathan Jacko in Investment Services. Can I have your first and last name, please?
Sheena Russell.
Thank you, and how can I help you today?
Hey there, I am calling on behalf of Rita Shuck today. I'm account number R30. And I guess it seems to me, according to her record, that every year she pulls money from some accounts to go into her checking account. She has got records. She's got records of everything. She has like stacks and stacks of records. But I cannot figure out where she pulled her allowance for the year from. Can you look and see if that comes from her investment account with you guys somehow?
Yeah, do you have dollar amount? Can you give me an idea of how much?
Let me find the Edwin paperwork again. The last deposit was $18,000 even, and that was in November of 2019.
Okay, perfect. And if I could just speak to her really, really quickly.
Oh, yeah, absolutely.
We'll get right to it, okay?
Yeah, absolutely. Hang on 1 second. Hey, Miss Rita. Hey, honey. So, please, Mom. The guy from USAA, he needs to talk to you just to verify that it's okay that I'm representing you, okay? All right, let me turn the TV down. Okay, all right, here he is, okay? Hello?
Hello, this is Jonathan Jacko with USAA. Can I have your first and last name, please?
Yes, Rita, R-I-T-A, Shuck, S-H-U-C-K.
Thank you, Ms. Shuck. And I have a couple quick security questions for you, okay?
Mm-hmm.
Can I please have your USAA 4-digit PIN number? Does anything come to mind?
No, it doesn't. No.
Let's do this. Can I have your phone password that is Japanese wildflower?
Yes, that is correct.
Can I have your phone password? Ms. Shuck, that is Japanese wildflower?
Yes, that is it. Oh, Japanese wildflower, excuse me. I'm sorry, it's, oh my God, Will's Tears, I'm sorry.
Thank you so much. Let's see what else.
I'm going to stop it there, and that sort of details what we talked about her getting the code word at that time.
Yes.
And initially cooperating or helping with her. There's another phone call after, it's March 13th of 2020 that details sort of the same thing, the code words used in that one. What I'm going to play is that one that you said that was suspicious, that was 323. I'm going to go ahead and play that.
Thank you for calling USA. This is Cameron Cooper and Broker Services. It's a pleasure of speaking today. Thank you, I appreciate that. All right, Ms. Shuck, I'm pulling up your account now. What prompted you to call in today?
Hello. I'm happy to, we are, I'm old, I'm a little older now. I'll be 90 from summer. My next birthday. I've lived a long time. And I'm having to, start having, in-home help. And that's rather expensive beyond what my insurance will cover. So, I didn't anticipate necessarily living to be the case. And so I'm having to pull money to ensure that I'm able to stay in the comfort of my own home.
Okay. So what are you wanting to do? I know you have a trust account. There's quite a few different shares in the trust. I know you're 97, and it'll be 98 this summer, which I think is fantastic. You sound relatively healthy. What are we looking to do for you on your trust account?
I just need to be able to install funds to put into an account that I can access it, a little more easily to be able to pay for these services.
Are you wanting to sell out of all of your shares of the company you have and just have cash? Is that what you're wanting? Or?
No, not all, no. What I need currently, would only be a portion, a small portion. Because I do understand that it's quite different than what it was last month I received my statement. I do realize that the accounts have kind of taken a downturn.
Yes, the virus and the market's really been volatile right now.
Yes, yes.
Let me explain something to you that's going to be helpful to you, okay?
Okay.
You have $85,000 in cash in this account right now. You haven't lost money on that $85,000. It's just sitting in cash. So you can transfer that money out at any time. It's liquid cash. Your stocks, anything you need to sell or want to sell, you would sell. It would take about 3 to 5 business days before the cash would come in, and then you could take that money out at any time. But you currently already have 85 grand sitting in cash. Now, here's something that's going to be helpful for you, that may be helpful for you to think about. This is a brokerage account, and it's going to go to Charles Schwab this summer. That's going to happen automatically. You don't have to do anything with that. We sold our brokerage account to Schwab. We announced that, so your insurance is going to stay to a day, but we're not going to have a brokerage account anymore. The reason I mentioned this to you is because there is going to be a change, but I know that Schwab offers check writing on their brokerage accounts. So when it goes to Schwab, you may be able to call them, and then maybe they can issue you some checks on your account, and then you could write checks directly from your brokerage account, and that might be helpful for your situation. Because right now, we can't give you checks to this account. We don't have the capacity to just do that at USAA now. So we would have to transfer any money you want into a checking account. But this, your situation with what you're looking for.
I'm going to go ahead and stop it there. It goes on for a while. There's some more kind of summation-wise this. Eventually, did she ask for $75,000 to be brought to her or sent in a check?
Yes, sir.
Okay. And there are some problems with that in subsequent calls. Essentially, she wasn't able to get into the P.O. box and access that check.
Yes, she was on the phone with USAA. At first, she didn't know the number for the P.O. box, which he provided to her, and then she said, go ahead and send the $75,000 to the P.O. box. But then after, I guess, the check must have got there, realized because it's in the trust name, she wasn't going to be able to cash it. So in a subsequent conversation, she opens a checking account, and then they canceled the other check and then was able to transfer that money into that checking account at USAA.
And that money from USAA then went to?
Darden, yeah.
And that was her account, so that
Yes.
further gives you evidence that that was her that was doing that.
Yeah, directly to her account.
The last portion of the call is one of those other calls that she calls in. There's a portion where they ask for the code word. I'll play that about 1 minute and 30 seconds.
Judge, may I be heard?
Yes, sir.
And it's in the form of an objection. Here's some things that are absolutely unrebutted. There's an agreement with respect to the amount of restitution. That's not in question. We're not going to raise that, and the state knows that we've cooperated fully. She's taken responsibility because she's entered a plea in this matter. We're not seeking and will not seek to take the position that this was an unsophisticated act by the defendant. We're not going that route at all. I don't know the purpose of this. This might be something that we would hear at a trial, but a plea's been entered. Responsibility has been taken, and so we object because it's unnecessary to hear this. I don't know what purpose is being served given the cooperation and the plea that's already been entered, and there's no mystery as to the amount of restitution.
And the purpose for this is it's aggravating, Judge. It shows the length of deception that went through. This didn't occur over one day, as they're saying. It's not unsophisticated, but it wasn't a one-off experience. It wasn't a one-time event. It wasn't one accident in the sense of things. It also shows it's aggravating. It's her impersonating it. It wasn't some other mode. It took deception. I think it's important for the court to hear that for exactly the reasons of purposes for sentencing, which is, again, it's aggravating in my mind from the state's perspective, the way that's done. The last portion of this recording is just simply she details the code word that she had previously heard. That's the purpose of why I presented this. It shows it was deceptive. It was done over the course of a whole month, these recordings, and additionally the other subsequent recordings previously. When she went to Missouri, when the victim moved to Missouri, she continued to lie about it at that time and said it was a business entity that was going on. I think it's highly important to see, for purposes of sentencing, the defense's argument that she's cooperative. I think it shows it's deception. I think it shows that there's aggravating things that occurred in this case that the court needs to hear to be fully aware of what occurred in this case. So I think it is relevant for those purposes.
That's what was in the information. She pled guilty.
Does the defense intend to exercise the reservation provided in the plea agreement to seek a departure?
Yes.
Okay, overruled.
Again, the last portion, I believe, and I kind of already detailed it, is the final recording on 3/30/2020. Essentially, they ask her for the code word. Again, kind of further.
All right, so, okay, then to verify really quickly, both, you have the both password here again, is Japanese sea creature. Yeah, the Japanese sea creature, right?
And in that, they ask her to see creature, not to see flower, and she indicates the widow's tear.
Yes, yeah, it should have been, well, she was, I believe, the only one prior to this in the recordings that was heard would have been Japanese wildflower, which was widow's tears. What they're asking for in that is Japanese sea creature, and in one of the recordings that Rita had with USAA later, she actually remembers it, and it starts with, "Oh, I can't remember it. It is a Japanese word." So, yes, but she wasn't supplied that prior, so she wouldn't have that information.
And this money, you went through some of those records as well. What was it mainly spent on?
Trips to Disney, trips to Vail and Utah, Dollywood in Pigeon Forge, DC, Bahamas.
I have no other questions at this time.
Do you wish to inquire?
Your Honor, I have no questions of this witness. Thank you, sir.
Thank you. Thank you, sir.
State's next witness is Amy Martin.
Amy Martin. Remain standing and raise your right hand to be sworn by the clerk.
Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do.
Please be seated and direct your voice to the microphone. Speak clearly and distinctly for us, and if there are objections, stop speaking until you receive an instruction.
Would you please state your name for the court?
Amy Martin.
And Ms. Martin, where do you work?
I work at the state attorney's office.
How long have you been there?
I've been there for, since 2015 I came back. Yeah, 2015.
What sort of
part-time, then 2018 is when I started full-time.
What sort of education and training do you have?
I have a law degree.
And have you completed CLEs and other training courses and things?
Yes.
Okay. What sort of work do you do for the state attorney's office?
I basically do paralegal work, analyze bank accounts, review discovery, prepare discoveries, other paralegal tasks.
But some of your primary duties are analyzing bank records and preparing charts, is that right?
Charts and summaries.
Okay. And you've been doing that for a while?
5 years.
And you've done that
Well,
with-
I've done that since I've been there, but full-time now with the state attorney's office for 5
And you were
years.
hired from previous prosecutor Russ Edgar to do that type of work?
Yes.
Okay. And you've worked on major cases previously with economic crimes?
Yes.
And you've also prepared statements or summaries for those cases?
Yes.
And you've testified before at sentencing?
Yes.
Okay. Are you familiar with this case involving Sheena Russell?
I am.
And what did you review in this case?
I reviewed the Darden bank records, the USAA bank records, the Charles Schwab records, and the Eglin records.
Okay. And in doing that, that time period you looked at was primarily between March 2020 and October 2021?
Yes.
That's the time period of the charged conduct?
Yes.
Okay. And in doing that, did you prepare some summaries?
I did.
Okay. And that was from the voluminous bank records and other records that you've looked through?
Yes.
Okay. I'm going to approach with State's Exhibit 4, which is a composite.
Yeah. Yes.
And these are the notices. There's a notice of intent to use these summary proofs. I'm going to approach it on that.
Granted.
Do the recognize these?
Yes.
And those are summary proofs. Correct me if I'm wrong. E through H?
Yes.
Okay. Say would have moved those into evidence at this time?
Oh, no objection to those being offered?
They're admitted.
And admitted.
Okay. Kind of quickly looking through this, attachment E, what is that? Is that the transfers from?
That's the transfers from the different accounts into the Darden account.
Okay.
Or that eventually went into the Darden account.
And then F, what is that summary of?
F is the spending detail.
And that's essentially 60 pages of alphabetically arranged spending items?
Yes.
And then what is summary, this one, G?
G is the transactions compiled, so if there were multiple transactions from Amazon, they're not, the first one would have been all of them listed out. This one is just, it just says Amazon, and it has the total of all the ones that were from Amazon.
Attachment H is sort of further breakdown into categories.
Categories, mm-hmm.
Judge, I don't know if you can see that, if I can publish it to you so you can see it while we walk through this, or?
However you'd like to do it, sir. Mr. Flowers may want to be able to see, Mr. Shaw may be wanting to see him as well.
Post it up there.
Yes, sir. You're connected.
Should be up.
Well, I see your computer, but
That's not, apparently not mine. One second.
There it is.
Okay.
There's a problem. All right. And this is attachment. E, and that's what you had mentioned, that's sort of each individual transaction. Is that right?
Yes.
Okay, and maybe tiny up here. I'm gonna try to zoom in a little bit. Maybe too much. These transactions here that occurred, what's the dates for these? I'll use the laser pointer here.
March, April, May for the Eglin and the USAA, and then from June 2020 to October 2021, they're from the Charles Schwab account.
Okay. And those totals up to that amount there, is that right? 596,000 essentially. Okay. I'm going to scroll on through this. These are essentially 60, like we said, 64 pages of the individual transactions. I'm not going to go through each one of those for time reasons. But what I'd like to focus on is attachment G, which starts, I believe, at page 63 of this. 64. And on this, it's like by category,
No,
the
this
type
one
of
is-
things that
yeah,
what the
by
money
type. This
was
is-
spent on. On page 1, it's got Amazon for $1,000 or $8,000. I may just read through this if you can kind of highlight the important ones here. There's an Amex card as well for $2,000.
Deposit for the Atlantis Resort.
The Atlantis Resort deposit. As we move through, I'm just kind of run through it. On page 2, there's Boomerang Pizza, Capital One for $1,000. Charles Barnes, and you look through those records, that's for rent payments of $4,000. There's a Chase credit card to James Russell
Yes.
for $9,000. Page 3 has Delta Airlines for $7,000.
Yes.
I may not highlight all these, there's a lot. Looking through, let's see here. Maybe move on to page 5. There's a car payment for $3,000
Yes, and that was for.
for Hampton Hyundai.
Hampton Hyundai, it was back up on page 5, you passed it.
Yep.
And the memo on the check for that was a graduation car for Riley.
Okay. And then you have a Gulf Power bill
Yes.
as well,
Yes,
about $4,000.
yes.
And that's the totals that were spent on that.
Yes.
There's also, I'm going to kind of fast forward a little bit here. Page 7 has Patty Dive. That was dive training.
Patty Americas Inc., it's a dive center.
Okay. Page 8, there's PayPal payments.
Yes.
Okay. That's
Those
approximately.
were, some of them were eBay, some of them were various other, some of them were people, family members.
And there's about-
Other ones were just transferring money to the PayPal account.
Okay. And there was a bounce house as well. That was purchased for $1,000 or rented.
Yes.
You see the playhouse, PlayStation. I imagine Ms. Rita Shuck didn't play PlayStation. There's Quality Roofing, which was roofed, and that was looked into, and that was the roofing on their house?
On the Burton house.
Okay.
You passed the reliable land and title.
And what's important about that?
That was the Burton house.
Reliable land and title, that was payment for the house that they currently live in now, is that right?
Yes. Mhm.
That's $60,000. And that money came from Rita Shuck.
Yes.
Okay. There's some loans for vehicles on page 9, the Santander, about $3,000. One was for a Mazda.
Yes.
Is that right? Okay.
I think the Santander was a Mazda.
Page 10, there's payments of $1,000 for snow.com. What is that?
That was skiing.
Okay. Sprint and wireless bill.
That was for, under the name Brian Russell.
Okay. There's a large one on to SunTrust Bank as well for $31,000. Do you know anything about that one?
That was a car purchase of Volvo.
A Volvo? And then on page, I'm going to skip to page 11. There's a lot of loan payments in here as well. I believe there's 15,000 for a Super Ford.
Yes. for
6,000
Ford
for a
F-150.
Mazda, Avenger, and then there's a lot of transfers for loans as well.
Yes.
And then as we kind of mentioned, attachment H breaks down those into other categories. What were the significant amounts essentially spent on?
There was at least $51,000 spent on vacations. Up to 70 if you include the credit card had purchases that were vacation expenses. There were 4 trips to Disney.
So a lot of vacation, there was house expenditures and a lot of vehicles, that
Yes.
kind of summation. Okay. I don't have any other questions at this time.
No questions, Judge.
State has no other witnesses at this time. I'm going to provide these to the clerk.
Yes, please.
Yeah, and state has no other, we just have argument, no other witnesses or evidence at this time.
All right.
Your Honor, if we may, we'd like to call Teresa Magnus as a witness.
You may do so.
Thank you. Ms. Magnus?
Trying to give space.
And if you'd remain standing and raise your right hand to receive the oath by the clerk, please.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated and direct your voice to the microphone you see in front of you there. Speak clearly and distinctly so we can all hear you and the court reporter is able to make a good record of what you have to say. Is that all right?
Yes, thank you.
Okay. And if any of the lawyers object, please stop speaking immediately until you receive an instruction on how to proceed. Is that okay?
Okay, thank you.
Mr. Flowers, you may inquire.
Thank you, Judge. What is your name, ma'am?
Teresa Magnus.
Your mom?
Yes, I'm mom.
All right. Where do you live, ma'am?
I'm sorry?
Where do you live?
I live in Compass Lake in the Hills in Jackson County, Florida.
All right. And you're here today for these proceedings. Would that be an
Yes.
accurate statement?
That is correct.
Okay. What I'd like to do is for you to tell the court things that you might deem to be important. The judge has an important decision to make with respect to sentencing. You realize that your daughter entered a plea having admitted to taking a lot of money.
Yes,
And we've discussed that, and that's no secret. You're aware of that?
I am aware of that, yes.
During the time period, and I'm suggesting around 2020, those years, were you communicating much with your daughter during that period of time?
Not as much as normal, no.
Okay. Why is that?
Her daughter had died, my oldest granddaughter, and she just went into a very dark period there. She was on a normal basis. She would call us on a daily basis to check on us, myself and her dad, and she would communicate with us frequently, let us know what was going on in her life. And there would be periods of time during that we'd really get worried about her because of the lack of communication.
That was unusual.
That was very unusual, yes.
As I understand it, this was for about a 2-year period of time. Does that sound right?
Yes, and still on occasion, her grief, I call it grief, gets
Yes,
deep
ma'am.
enough that but at least now she will say, I just don't feel like talking, instead of just not communicating.
You became aware of this situation. How did you become aware of it, ma'am?
She told me.
All right. And she admitted to you that she
Yes.
she messed up or made
Yes.
a mistake. All right. You're aware, I think, and don't, if I'm wrong, I'm going to invite you to correct me, that the family helped her cobble together some money to pay back.
Yes,
Are you aware
we
of
did.
that?
Yes.
Is your family, and I know your family's here today, is your family supportive of her?
Yes, we are very supportive. Everyone that could come.
Knowing what she
come
did,
today.
knowing what she did was wrong.
Yes, because it's uncharacteristic.
You don't condone it, do you?
No.
I expect, very much expect, as does the state, and we have agreed that there's money that's owed, that she
Yes.
owes. Your family, I think, is going to try to help her, but you don't have the ability to pay it, do you?
No, sir, I do not at this time.
In the event she continues to work, and she is working, is that right at this time?
Yes, she is working.
In the event she's able to work and pay the money back, would you help her along the way if you could?
Oh, absolutely.
The times are tough.
Absolutely, I would, yes.
All right. Having raised her, or the things about her character that you knew were growing up that seem inconsistent with what we're talking about here today?
It's very inconsistent with what we're talking about today.
Would you be kind enough to tell the court about that, please?
Yes, from the time she was a teenager, anything that she wanted that was above a normal expense for that age group, we would give her the option of either not doing it or earning at least half of the money, and we would match the rest of it. She did that when she was wanting scuba diving lessons. She had to earn the money to buy her equipment, and then we would pay for the lessons. She did that also when she wanted to take a trip with the last year in junior high. She wanted to go on the 11th grade trip down to the Florida Keys with the marine biology class.
Yes, ma'am.
And in order to do that, it at that time was $750. And we promised her that we would pay half of it if she would earn the rest, because you had to put 50% of it down. And we did, and she did earn the rest of it, so she was able to go on her trip down to the Florida Keys. And
based on what you're telling the court, it seems to me that this period of time, and you've heard and are familiar with what she did, seems really out of character and totally unusual based on the daughter that you raised. Am I understanding that correctly?
if she had not have told me what she had done, I would have never believed it. Because I know that
Yes, ma'am.
it's very uncharacteristic.
When she did tell you,
Yes.
and she did, right?
Yes.
Was she sorry about it?
Oh, absolutely.
All right.
It was one of the hardest things she had to do, was tell me that.
All right. But she's still your daughter and you still love her?
Absolutely, she is. She always will be.
But she did the wrong thing, didn't she?
Yes, she did.
All right. Your Honor, those are my questions.
Mr. Gillespie.
Just briefly. Ms. Magnus, correct?
Yes.
When did her daughter pass away? Was it in May of 2020?
No, it was before that.
When was it?
It was in, gosh, my husband just passed away. 2018, 2019. 2019. I'm sorry, my husband just passed away, so, and I know this because that's my oldest granddaughter. I'm sorry,
Would it
I
shock you
cannot
if the
remember.
obituary
right
would
now.
be May of 2020? What was the daughter's name?
Brianna Marie
Brianna
Russell,
Marie.
yes.
Would it be surprising if the record showed that it was in May of 2020?
No, I wouldn't be surprised. Like I said, right now, in July 14th, I lost my husband of 43 years, so.
When did she tell you about the theft? Ms.
I'm
Russell?
sorry?
When did Ms. Russell tell you about the theft?
The death, the death.
The theft, the offense, the case?
Oh.
You had mentioned she had told you about this.
Well, she told me about it when she heard about it.
Okay.
The day she heard about it, she told me about it.
When she was arrested?
I don't know the details.
Okay.
I just know she called us and told us what had happened.
Okay. And you said this was uncharacteristic of her?
Very uncharacteristic of her.
Were you aware of her prior record of worthless checks, insufficient funds?
I was not at this time, no.
Okay. I have no other questions at this time. Thank you.
Any redirect?
Your Honor, I have no further questions. Thank you, ma'am.
Thank you, Ms. Magnus. You may step.
Thank you.
Give me space.
Your Honor, we would call Sheena Russell.
Sheena Russell. All right, remain standing, raise your right hand, and receive the oath by the clerk.
Do you swear affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? Yes. Thank you.
Please be seated and direct your voice to that microphone. Speak clearly and distinctly so we can all understand you. And if any of the lawyers object, stop speaking immediately until you receive instruction, okay?
Yes, sir.
Okay. Mr. Flowers.
You're Sheena Russell?
Yes, sir.
How old are you, Miss Russell?
49.
Miss Russell, you recall being arrested and charged with having taken this money.
Yes,
Is that
sir.
true?
Yes.
And you've hired Mr. Shaw and myself to represent you in this matter?
Yes, that's correct.
Have you been forthcoming in your discussions with us?
Yes, sir.
In fact, there came a day that before this court, you came in and entered a plea.
Yes.
Acknowledging that the state had enough evidence to prove that you did in fact wrongfully take money that wasn't yours.
Yes.
Is that true?
Yes, that's true.
And whose money was it?
Rita Shuck.
Okay. And to do so, you engaged in some fraudulent activity. Would that be a fair statement?
Yes.
Once you were arrested and we were dealing with the Office of the State Attorney here, have you admitted the amount of money that the state is seeking, and we've stipulated that that's an accurate number. Is that true?
Yes, that's correct.
You're working now, is that right?
Yes, sir.
Your family's here, your family's supportive of you. Would that be a fair statement?
Yes, sir.
Prior to coming here today, in fact, prior to entering the plea, there was a date that you're able to come up with some money towards restitution, and you paid it, didn't you?
Yes, sir.
How much money did you pay?
In total, $100,000.
You owe more money though, don't you?
Yes, sir.
One of the things that a court looks at is paying the money back. We call it restitution. You
Yes,
familiar
sir.
with that?
Yes.
Do you believe you should make restitution or pay back the money in this case?
Yes.
And if ordered to do so on a monthly basis, will you do so and make a payment every month?
Yes.
In the event you're working, you take money out of every check. Would you do that?
Yes.
Ms. Shuck didn't deserve to have her money taken.
No.
How do you feel about that?
Really, I'm very, very sorry. I feel very guilty. it makes me feel like a really bad person.
In coming to court, some would say, and lawyers argue, well, she's taking responsibility. Are you taking responsibility? I want you to tell the court, are you taking responsibility for your actions?
Yes. Yes, absolutely.
During this period of time, the early 2020s, that time frame that I think the state was educating the court or further educating the court about, what was going on, if anything, in your life that may have affected your decision making?
Oh my gosh, just so many things.
Well, I'd like for you to tell us about them, please.
My oldest daughter was an addict. I worked really hard. And I paid for insurance, and you know, she wasn't 26 yet, so she was going to be going off the insurance. But even when we tried to get her help, it was really expensive.
She was in a treatment facility?
She went to 5 different treatment facilities. She had wound up losing her children, my grandchildren. And she was living in her car in Pensacola. And she needed a lot of help, but she also finally, in 2019, was really trying to do things for herself and stay clean, not relapse.
Now, when was that time period, please?
It was 2009. Okay. So when she was living in her car was the beginning of 2019.
All right.
She was wanting to go back on a treatment. It's called a Suboxone treatment. And it's pretty expensive. Like, even with our insurance, it was like constantly, I was having to like call and ask for help to pay for it from my parents and my parents-in-law. It was like $1,000 a month for the prescription itself at that time, and like $370 for the doctor's appointment itself. And you had to go one time a month.
And this is your daughter that needed this, is that my understanding?
That's correct, yes. She had been on that treatment previously and was seeking to go back on it. Because she was really scared that she could not stay clean without it. So, and she was living in her car, and she wanted to be able to get clean, get her own place, have a job, be able to be stable so that she could at least even be able to see her children. At the time, she was only able to see them through visitation, like at the Families First Network.
And that was pursuant to a court order, is my understanding.
That was
Am I right
a court
about
order.
that?
Yes.
All right. Now,
Yes.
one of the things that Mr. Gillespie and the witnesses have pointed out is the amount of money. It's a large amount of money.
Sir.
But he also pointed out, and I want you to talk about this, where the money was spent.
Yes, sir.
All right. I'll take a topic. I think they listed a topic, quote, vacations.
Yes, sir.
Who went on those vacations?
The kids, grandkids.
These are your daughter's children?
Yes, that's correct.
Okay. And there were a few of those, is that right?
That's correct, yes, sir.
We all want to know, why'd you do that?
Oh, that time is very, very, very surreal. But I became kind of hyper fixated, and this is me looking back. And I'm still working on it with my counselor to try to understand what all happened and my thought processes.
Tell the judge what you believe the truth is.
I thought the world was ending. I thought it was COVID. My daughter died. I thought everything was over. It was like escapism to a certain extent. I was really, at times even like kind of a little bit confused. I didn't realize how much time had passed sometimes. But it was weird because like I was working. It's like this one part of me was like same old. Like I was going to work and doing everything that I normally did. But it was really, really, really hard and it hurt a lot.
If I were to say the word hopeless.
Oh, definitely. Like beyond hopeless. Like literally, I thought that I'm sure probably the ending of the world seems a little bit differently for everybody. But when I say that, I literally thought that, like, I just thought I was just gonna, like, die at any moment. And honestly, it didn't matter. Like, it didn't. I wanted to make sure that my kids and my grandkids were okay.
I'm going to ask you a tough question. In 2020, with the things you were going through and you've described, did you think you'd be alive right now in 2025?
Oh, no. Absolutely not. I didn't think I'd be here, and I didn't think it would matter if I was or not.
Mr. Gillespie did what I believe to be a fine job of presenting the numbers.
Yes, sir.
And what they were spent for. Have you or Mr. Shaw, myself, in any way sought to do anything but cooperate in them assimilating that information?
Not to my knowledge, no. I have not.
Do you believe the numbers?
Yes, sir.
That Mr. Gillespie provided without our questioning them are accurate numbers for this court to rely upon?
Yes, sir.
And Mr. Gillespie pointed out there was an $8,000 error in our favor earlier today. You don't question that?
No, sir.
Or quite frankly, his honesty. He's been as honest as he can be as far as you're concerned. Is that
yes.
right? But you paid that $100,000, right?
Yes, sir.
Now, you're aware of the pre-sentence investigation that was, in fact, you participated in that, did you not?
Yes, sir, I did.
And we've read it. We've all read it.
Yeah.
I read in there that they knew that you had paid $100,000, meaning the family.
Yes, sir.
And the gentleman that testified earlier from the family, he was genuinely interested. I think he testified earlier there was restitution. They were interested in that. Did you hear him say that?
I'm sorry, repeat
Did you hear him say that they are interested in restitution?
Yes, yes.
But I believe he said also, and correct me if I didn't hear this correctly, that he was asking for the court to give a maximum prison sentence.
Yes, sir.
Do you remember in the PSI where they said they might not want a maximum sentence if you paid them more money? You remember that?
Yes, I believe that it was blacked out on my copy, but y'all read that to me. Yes, I do remember seeing that, yes.
You're not able to pay a lump sum right now, are you?
No, sir.
Are you able to make monthly payments if you could keep your job?
Yes, sir. Yes.
Prior to this incident, you had some bad checks. Yes,
sir. That was, I believe, like a fairly long time ago, but yes, sir.
Did you bounce checks? What was that about?
One of them was actually taken care of before it was filed, and so I wound up just having to pay the fee. It was a partial rent check to Jill Pullum.
You bounced a check?
Yes, I did bounce it, but then I went and paid it, but she filed with the county before, I guess, she said it was before she knew it was paid.
How about the others?
It was like $30-something at Walmart, and
nothing like this.
Yeah, no, it was like 31-something at Walmart, and then I'm gonna be honest, I don't remember what the other two were.
All right.
I apologize.
Please.
You may, sir.
Now, you knew that I was going to ask you questions today, but
Yes, sir.
likewise, I believe that you had written something also.
I did, yes, sir.
Do you have that with you?
I do, yes.
Would you like to read your statement that you prepared
Yes.
for the court's consideration?
Yes, if that's.
Well, with the
okay.
court's permission, Your Honor, may she do so?
Yes, sir.
Okay. Your Honor, I wanted to keep my statement simple out of the utmost respect for this court and for all parties involved. I have always believed in perseverance, hard work, and integrity, but there are moments in life that change you at the very core. Several years ago, I faced events that shook my faith in everything. I truly felt as though my world had ended. In that time of crisis, I found a like-minded friend, and the storm we were both in clouded my judgment. I have not yet fully returned to the person I was before. I stand here today before my family in this court, taking full responsibility for my actions. I can only describe that period as an alternate reality, one where my sole focus became making sure my children and grandchildren would be okay, even if I didn't believe I would be there myself. Over these past 5 years and 4 months, I have reflected deeply on my choices, searching for understanding. That reflection has shown me that you must truly know yourself to own your mistakes and to ensure you never cause harm to yourself or others. I have never held harmful intentions toward anyone, and I am making a conscious commitment to keep that mirror in front of me, to hold myself accountable every day. The truth is, I had been carrying hurt for a long time. I have always worked hard for what I wanted, but especially after losing my daughter, Brianna, I felt life owed me something. I was exhausted from struggling, from not being able or being unable to get her the care she needed, the right treatment, the right resources, the stability that she deserved. When an opportunity came that promised financial security, I thought, this is it. I can finally help my family and build something lasting. At least that was my thought process at that time, as best as I recall. I am not making excuses. I want to compose myself a little bit before I read this part, please. I am not making excuses. The reality is, when you're living your worst nightmare without time to care for your mental health, every moment feels like an emergency. That is no way to live. It leaves you vulnerable, clouding your judgment. And yet, no matter the circumstances, you are still responsible for putting in the work and reflection needed to live a life you can be proud of and those around you can be proud of. Your Honor, I'm here today owning my mistakes, accepting my responsibility, and committing to building a better, more accountable life. I will carry these lessons with me always. Thank you for your time and consideration.
One final question, if I might. You are working, you have your supportive family and your husband.
Yes, sir.
You've likewise been receiving counseling, is that true?
That's correct. I had a little bit of a lapse in it, though, because I did not have health insurance for a while. But the health insurance I have right now, it's a $10 copay, so it's very attainable now.
You're sorry about what you did?
Yes, very. And I own that.
Your Honor, those are my questions. Thank you.
Mr. Gillespie.
Mr. Russell, I have a couple questions for you. I know it's difficult at times, but most can be answered with a yes or no.
Yes,
Some will
sir.
require some more explanation, though. How long did you know Miss Rita Shuck?
Since 1996.
And how did you know her?
I was a waitress at the Olive Garden in Fort Walton Beach, Florida at that time. I was pregnant with Elspeth. I was pregnant with my second daughter.
How often would she come in?
During that time, her and Warren would come in, regularly enough, but after I had Elspeth, I actually moved away.
But how long would you say you had a relationship with Miss Rita Shuck then?
Like a friendship? Oh gosh, that wouldn't have been until like where we were like friends until 2005.
So over 20 years.
Yes, sir.
Okay. Why was it at this moment that were you aware that she had all this money?
No, she was thrifty, but at the same time, her and Warren both they helped people. So she never really talked about it or anything like that. And she always liked to wear her thrifty clothes and her beads and all that stuff. And she was really proud of recycling and upcycling. She was very, very much into the Japanese culture as far as that goes.
So it wasn't until March of 2020 that you started taking this money out of the accounts, is that correct?
I'm going to be honest, I don't remember the exact date.
Okay. Your daughter passed away in May of 2020?
That's correct. It was May 23rd, 2020.
Okay, and that was you on the audio recording that we heard earlier, is that
Yes,
correct?
sir.
And that was you impersonating her, correct?
Yes, sir.
Okay.
Yeah, I don't recall. I recognize my voice, even if I don't recall anything else surrounding that.
Okay. And you'd mentioned, and we kind of walked through that, some of it, you spent this money on trips and other things such as that, restaurants and other items.
Yes, sir. Anything that was a special occasion, especially, I tried to make it, like I said earlier, it's really weird. I was like, normally you plan for the future, and it just was like, all we have is right now or something. I don't know.
There's money that was spent on vehicles as well?
Yes, sir.
Do you know how many vehicles you purchased?
Well, we already had vehicles.
Okay. Was there a Volvo that was purchased?
Yes, sir. I do. Yes, I have a payment on that vehicle.
Okay.
Yes.
And a Mazda?
We already had the Mazda.
Okay, there was payments for that, though, is what I saw in the records, and also some service charges.
I remember seeing it, but I'm gonna be 100% honest. I don't remember the details of that.
Do you still have these vehicles?
Some, yes.
How many vehicles?
Oh,
do
the
you
Mazda and the Volvo, yes.
How many vehicles do you have currently?
Just those two, and then my husband's work truck.
Okay. And you, where are you living currently?
At Burton Circle.
Okay. And that house was purchased with money from Rita Shuck as well?
She did gift us some money to be able to go ahead and get that, yes.
Okay. And you still reside in that house currently, correct?
Yes, that's correct. We don't really have any other choice at the moment. If I could sell it, if I could liquidate it, I would, to be able to that's the ultimate goal.
What's preventing you from doing
that? We had an SBA loan to repair the house, and they only care about the storm damage part. There's we wouldn't be able to, with the cosmetic things that aren't complete, we would not be able to get enough money currently to pay that SBA loan and be able to have anything of substance.
There's 2 SBA loans that are attached to the house as liens, is that correct?
It's one, it just was modified to complete. Once they kind of got into looking at more damage, there was water damage like in the walls and stuff, because it took so long to get the roof repaired. So originally, the SBA loan was a certain amount, but then it had to be modified to finish those repairs.
Okay.
But yes, that is the lien.
Did you ever reach out to law enforcement to talk about this case?
An investigator called me. I think Investigator Kruger called me.
Did you speak with him?
Yes, I did.
Did you refer him to an attorney?
I did. Originally, I had went ahead and hired an attorney when I was informed of the investigation because I didn't really understand what was happening at first. So I hired an attorney in South Florida, and they had told me not to answer anything or talk to anyone.
Have you answered or talked with anyone about these charts or money or anything else until today?
Oh, yes.
About the charts and things, well, other than your attorneys?
Well, yes. I mean, I've talked to my family. I've been very open with them about everything that they would see here today. I mean, I was really open and talked to my family about it before I was arrested.
You haven't talked to any investigators or any?
Oh, investigators. I'm sorry. I don't think so.
One moment. No further questions. Thank you.
Mr. Flowers.
Your Honor, I have no further questions of Ms. Russell.
All right.
Your Honor, we have no further witnesses that we wish to present. I don't know Mr. Gillespie's position. We would anticipate making comment to the court.
Judge, I have two affidavits that I provided previously to Mr. Flowers as well that are basically letters from the Department of Corrections. I'm not sure exactly which, I didn't hear exactly which parts that he's looking to depart or what reasons he's looking to depart, but they cover sort of the mental health and physical aspects that are covered in the PSI. I'd like to introduce 5 and 6 as the affidavits for that.
Kind of can look for it.
Yeah, one's for mental health and one's for physical.
All right. Well.
Judge, we've no objection to states 5 and 6 being admitted. And if I could, Mr. Gillespie asked a fair question with respect to the mitigating circumstances that have been clearly testified to, and I'll point them out. The need for payment of restitution, which was outweighs the need for prison sentence, was consistent with Mr. Peck's comment in the PSI and her desire to make restitution, and that's our position. And her position mentally, physically, and emotionally at the time of these offenses adversely affected her appreciate any decision-making she was involved in. In fact, she didn't even think she'd be alive. So we would argue that her capacity to appreciate the nature of her conduct was substantially impaired. We believe that the evidence unrebuttedly shows that. With respect to cooperation with the state, I think Mr. Gillespie would agree we couldn't have cooperated anymore with respect to challenging evidence, cooperating. The numbers were agreed to. She entered a plea. That's our position, Your Honor. And again, we have no further evidence that we seek to present.
Mr. Gillespie.
Judge, I think, I don't know if I should address the departures first or just kind of give overall, but looking at this case, this is a case of elder exploitation. As detailed now, she's agreed to in the plea. There was a cap of 7.5 years of incarceration that was capped. Part of that, and as noted in the plea, the defendant did provide $100,000 in restitution immediately for that. That sentence was encapsulated that amount that we had plea negotiations back and forth about what that would be, what the cap should be, and based on restitution. As you note, there was discussions about that restitution.
Well, let me restate to be sure I understand. You're saying that the payment of that amount of restitution is what resulted in the agreement of the state to grant the cap of 7.
That's correct. It's detailed in the agreement itself that that's the cap and that's the restitution.
I'm sorry to interrupt. Go ahead.
Just sort of addressing the overarching thing, this is a large amount of money that was stolen from an individual victim that was over 98 years old, I believe, at the time of this. It is a significant amount of money, over $500,000. It's not a small amount of money that's involved with this. And looking at whether to depart, court has to look at first whether they can depart, whether there's been competent substantial evidence or evidence that was proven at court today. And then the second part of that question is, even if it was proven, should the court do that? The three that they have sort of detailed here was the need for restitution. As mentioned, there is outstanding restitution of a significant amount. There's about $200,000 that's owed to the victim directly. The other ones are for financial institutions. As we heard from Mr. Peck, Ms. Shuck is doing okay now. She has had some of the money returned. She's stable in a home. There's no worry of destitution, essentially, of her becoming sort of a ward of the state or ending up on the street or anything like that. She's got a support network as well. The case law that details the need for restitution often says there must be a pressing need. And I grant it's usually in situations such as an elder exploitation where someone will be wound up on the street. That's not what we have in this case. Obviously, Mr. Peck would like the restitution. The family would like the restitution. My understanding is a lot of that will go. Ms. Rita Shuck is now 103. I suspect a lot of that money will go through the trust, as it was mentioned, to basically this school and these other individuals once it passes through. I don't think that one's been proven. I think that the type of case that this is, as the victim, Mr. Peck detailed, it doesn't outweigh this need for an incarcerative sentence. I think that is something that's important, and I don't think that's a grounded depart. The other one was that she didn't understand the sort of consequences of what she was doing. I don't think that that's been proven either, in the sense of things. She has a prior record, while not significant. She has prior worthless checks, credit issues of that nature. I do think she appreciated the nature of what she was doing, and that's why I presented that evidence. The reason I do think that is because she purposely was deceptive in doing it. She pretended to be Miss Rita Shuck on the phone, which we heard and she admitted to, and took money. I don't think that was a state of not understanding what's going on. Her daughter, it is tragic. Sentencings are never happy times, I feel like. But it's tragic that her daughter passed. But the fraud that was committed and those initial transactions, the 4 transactions, which I think were over $100,000, occurred in March and early April before that death. Then the floodgates did open, and as you saw, she took a massive amount of money, and it was spent, in the state's opinion, frivolously on items that she did not need. It's not for necessity. These are extra cars. These are vacations. These are things that are not necessities. I do think she understood what she was doing. I don't think that's a ground of depart. As far as cooperation goes, I do think, and I'll admit, she did provide $100,000. That is rare in these type of cases, and I've said it to defense, I'll say it as well today, that is a large mitigator. The victims agree as well that if she can come up with more money, that would be a large mitigator for prison time. But right now, that's what we are at, is at 7.5 years for that. As far as those departures, I think that that's encapsulating a lot of what we're talking about here. Again, this isn't some random event. This was someone she knew for 20 years, that suddenly she decided to pillage the accounts, deceptively pretend to be herself, or be Rita, and not herself, and took a large amount of money. What was also important that I brought to the court's attention was even when she moved to Missouri, she continued to take money out of the account. There's another 2 transactions on, I think it's Exhibit 8 or G. There are 2 transactions that occurred while she was in Missouri. The victim was in Missouri. And she lied to the Darden bank representative then, saying it was a business venture that they were taking. This is a case that warrants a prison sentence and incarcerated time. As Mr. Peck had said, I think that is something that needs to be done so it doesn't happen in the future, that there is a deterrent factor in this. Punishment certainly can't be cruel, but it's not supposed to be convenient or comfortable either. I think that the state's asking for 7.5 years, followed by probation with terms and conditions. I have a list of terms and conditions I would recommend if she's put on probation to include submitting all her financial accounts, working and maintaining employment, anti-theft course.
I'm sorry, you said submitting her financial accounts.
So I would ask that, I can read through, what I would ask for is a 7.5 years with the restitution that's stipulated to, and we've come up with that new figure based on those changes, which is $707,333.21, and the figure on Ms. Rita's has changed. And then we'd ask for essentially the 22 years of probation to follow for her to make that restitution with minimum monthly payments. I kind of leave that at the court's discretion, maybe $1,000 per month or $500 per month. I'd ask that the restitution go to Rita Shuck first, if it can be allocated that way through probation. I'd ask that the defendant would maintain employment or submit 3 applications per week and accept any offers. To notify any future employer of her probation status. Submit probation and affidavit listing all of her financial accounts, which would include bank accounts, retirement accounts, brokerage accounts. Submit to probation and affidavit listing all owned assets, including her properties, her vehicles, her business interests. And submit to probation affidavit of her monthly income and expenses. I think for conditions, something that would be helpful, more rehabilitative, financial literacy course, if there's something permitted, complete an anti-theft course, and complete a mental health screening and any recommended treatment, and have no contact with Rita Shuck or her family. Those would be conditions of probation. It is within the court's discretion to depart. I would note that it must be an adjudication of guilt as it's a first-degree felony per statute. It is in your discretion to depart. I think for the reasons I've presented that this is not a case, one, I don't believe it's been proven, and I'd ask, judge make a ruling on that, whether it's been proven or not, and then second, whether it should be done, and we'd ask that you don't do that. I don't think this is the type of case to depart. The lowest permissive sentence is 34.5 months. The victim's asking for the cap of 7.5. The state's asking for the cap of 7.5 as well. Thank you.
Judge Mayer.
Mr. Flowers.
First, I think it's accurate for the defense to present that the 34.5 months guidelines, which is the bottom end of the guidelines, does in fact take into consideration all of what the state has argued to be aggravating factors in this case, and that's the law, and that is clear. It is also clear that $100,000 was paid in advance, and when Mr. Peck took the stand today, quite frankly, one understands his position, and I respect it. And as he said in the pre-sentence investigation when he was questioned as the representative of the family, that in the event she was able to pay another lump sum amount of money, that he would agree to adjust the incarceration. So for the state to suggest that restitution is something that's not of paramount importance, I think is inconsistent with that which the family's representative had testified to. I think the state is also correct, and I think it pointed out a recommendation for the court as a condition of probation that she receive a mental health screening. He's right. That is what she needs. That's what she has needed. It's consistent with what the testimony is today, and the state knows that to be true. He wouldn't have said it. What we would argue, Judge, is the mitigating factors that we pointed out have clearly been proven. We disagree with the state's assessment. Her mental health was Well, she thought it never occurred that she'd be alive. She was desperate, hopeless. Her daughter, because of poor choices she'd made in her health, had died. The need for payment of restitution, according to Mr. Peck as representative of the family, does outweigh the need for an incarcerative sentence, because he said if she'd pay more money, he'd ask the state for less prison time. That's what he said. Your Honor, what we're respectfully suggesting is this, that if the court finds that a prison sentence is appropriate, we would ask the court to order a prison sentence, but to suspend it for a long period of time, for instance, 10 years of probation, and order her during the 10 years of probation to do that which the victim's family has asked. Make her get a mental health evaluation. See to it that she's working, and see to it that on a monthly basis she does what she has already begun doing, and that is pay this money back. Judge, we respectfully suggest that the defense has proven the mitigating circumstances. They should be given great weight. We're asking the court to, in the alternative, either give her 34.5 months, State of Florida Department of Corrections as a sentence with appropriate sanctions as far as probation is concerned, which we would anticipate the court to order, or to order an incarcerative sentence, but to suspend that with the safeguards in place and the restitution ordered consistent with what we agree to be the money that is owed. And that is our position, Your Honor. Thank you.
Well, now, Mr. Flowers, you do agree, though, for the court to give a suspended sentence under the circumstances presented, I would have to make the finding that you had met the criteria for departure, right? And that it was appropriate, right?
Yes, and we believe that we've done both, and I do agree with that, with the court's assessment of the law. I believe you're accurate, Your Honor.
All right. All right. Anything else, Mr. Gillespie?
Judge, I can't remember if I submitted the
Can we get
affidavits.
the affidavits, Madam
I have them
Clerk?
right here.
Okay.
Those are the ones I saw?
You tender those to Madam Clerk, please.
Judge, I think, I can't remember if Mr. Flowers the first right it, but just an abundance of caution, make sure the record's clear on that. I did provide those affidavits. Department of Corrections has, I include in those affidavits, sophisticated or detailed policies as far as treatment plans and everything else that goes with mental health or any physical health. There might be something detailed in the PSI regarding that. And the other thing, I'm not sure if I hit it, and I'm just an abundance of caution to lay the record. As far as the cooperation, as I mentioned, she never really reached out. My understanding of the case law is that cooperation needs to be more than just entering a plea. There needs to be some, she never reached out to law enforcement, those sort of details. I will say, again, as I've said before, she did provide $100,000, but I don't believe that meets the criteria for cooperation in the sense of it's.
The downward departure criteria for cooperated to resolve the offense is not making a plea. That is cooperating before the plea to resolve the offense. It's not making a plea. So that downward departure criteria has not been met. The court's listened carefully to the testimony of the defendant and her heartrending circumstances of her family situation. I was just, Mr. Flowers knows, we've done this for a long time, and we hear lots of stories. And this one has been a difficult one to hear the circumstances of the defendant. With that said, though, that set of circumstances, based upon the prevailing case law, the court does not believe meets the criteria for a departure on the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of the law was substantially impaired. The prevailing case law would not support that finding. So that leaves the court with the question of the need for payment of restitution. The victim outweighs the need for the prison sentence. Once again, the prevailing case law is that the question is the need of the victim is really the question. And here the victim's representative has indicated that the victim is in a position of not, I mean, it's hard to say nobody needs 500 and something $1,000, but the defendant is not destitute where the need for a monthly payment of restitution would make the difference between the victim being a ward of the state and living a decent lifestyle, which has been testified to the victim's representative. And contrary to what I hear the argument, I read again the PSI, and the victim's approach has been that they would consider as additional mitigation a lower sentence if additional lump sums were paid, but that's not where we are, and the victim's representatives have been consistent that they believe that a prison sentence is appropriate. So the court does not believe that any of the mitigators have been met to the preponderance of the evidence. And so the court does not believe that the court has the ability to depart downward. Now, assuming I'm incorrect about that, I would then address, even if they had met one of those criteria, whether the circumstances were appropriate. After hearing all the evidence that I've heard today at the sentencing, I do not find that it would be appropriate to depart downward under the circumstances presented. I don't feel like the circumstances presented here over a period of 19 months, the defendant in this case took an average of almost $31,000 a month from the victim. Although I suppose one could argue some of the payments were for circumstances that would support reasonable needs, the prevailing testimony, the overwhelming testimony, is that it was spent on things that were of not a durable nature, that were frivolous, considering the defendant's otherwise modest circumstances, and just wholly lacking of any regard for the circumstances that she placed the victim in. So the court would not find that it would be appropriate to depart downward under the circumstances presented. So with that in mind, if you'll present yourself in the lectern with your client, please, Mr. Flowers, Mr. Shaw. I've listened carefully to all of this, and you know I haven't supervised this case for the whole time. I'm new on this case, but the plea has been given and accepted by the court, and we've listened to the sentencing. I've read the PSI. I've heard everyone, and given the circumstances presented in this situation, the court finds that it is appropriate to impose the 90 months that's agreed to in the cap, followed by 22 years of probation. Will provide that the defendant must get and maintain employment or seek employment, and based upon the circumstances, as the lawyers know, that if the defendant seeks to do training or other education to support her recovery after her completion of her sentence, that I'll support that as part of her employment or seeking employment if that's what she wants to do, because I believe that's what will set her up for success. We'll have, after she finishes that and gets her employment, then it'll be $1,000 a month, minimum payments towards her restitution, and she will have to submit her accounts to probation as part of the regular auditing. She'll have to submit a statement of her property ownership as well, take the financial literacy class, the anti-theft course, do the mental health evaluation and recommended treatment, no contact with the victim or the victim's family, and in addition to the other standard terms of probation, including the $40 cost of supervision. And what are the appropriate fines, fees, and costs, Madam Clerk, in this case?
$515.
$515 in this case of the fees and costs. And the court will provide that the restitution payment should be made first directly to the individual victim until that restitution is satisfied, and then the payments would begin to the financial institutions. The court realizes that this is a change from the ordinary process. However, based upon the circumstances presented, the court believes that that represents the most equitable distribution of the restitution, and also represents, I believe, what the defendant, based upon her expressed desire in her testimony, wishes for the best results to be as well, and also supports what the victim's representatives have indicated. Any question about the court's sentence and judgment?
No question, Your Honor.
None from state.
All right. That'll be the order and sentence of the court.
Thank you.
Your Honor, probation does have a question.
Yes, ma'am.
Restitution will go to the individual victim, and then upon her passing, go to the individual financial institution?
No, it's actually to her trust, the individual's trust, because the trust is for her support, and it is a irrevocable trust, and so it survives her, so the payments would be continuing to her irrevocable trust until the restitution is satisfied. Is that right, Mr. Peck? Okay. So it would be to her trust, and once it's satisfied to the trust, then it would go to the institutions. Anything further today?
Nothing
further. So, Judge.
Will be adjourned.